Thank you very much. Good afternoon and welcome to the Senate Committee on Education. Welcome to those online and present on phone. Will the Secretary please call the roll?
Vice Chair Dondero Loop.
Here.
Senator Hardy.
Here.
Senator Hammond.
Here.
Senator Lang.
Here.
Senator Buck.
Here.
Senator Donate.
Here.
Chair Dennis.
Here, thank you very much. I believe everybody's here. We have a quorum. For those on video, please keep yourself muted when not speaking. Also, if you need any of the committee information, it's available on Nellis. So any of the documents for the work session and everything are all on Nellis. And you can also watch it on Nellis or YouTube, which you probably have figured out by now. And when you're testifying, please register to participate through Nellis, and you'll receive an email confirmation with the call-in information. I will take public comment at the end of the meeting, and you're limited to 2 minutes per person. We do have one bill that we'll hear today, so we'll also hear testimony in those, and we are going to limit that to 2 minutes also. And I will limit public comment also the full amount, just so that we make sure we can get done with this, with our meeting today on this deadline day, and make sure that everybody can get to the other meetings that they need to. You can also submit written comments by emailing or faxing them to the committee manager. With that, I am going to follow the agenda in the order that it is, starting with our bill that we will hear, and then we'll go into work session. Hopefully I don't lose any of my members. If you need to leave, make sure you let me know. So with that, we will start by hearing SB 224. So I will open the hearing on 224. This measure, where did it go? Revises provisions relating to large school districts, and Senator Harris is going to present that bill. So let's go. Let's have you go. And I know you have some other folks perhaps here with you to help you with that. So Senator Harris.
Thank you so much, Chair Dennis, Vice Chair Dondero Loop. Good afternoon, committee. My name is Dallas Harris, representing Senate District 11 in the southwest part of Clark County, and it is my pleasure to present Senate Bill 224 today. I'll keep it short and brief for all of you, as I know we are on a deadline day. This bill relates to collective bargaining agreements and the ability for administrators to surplus a certain subgroup of employees. I'll turn it over to Mr. Chris Daly to speak more about the bill in detail. And I believe he also has Ms. Matuska, hopefully I got that right, awesome, who will be available to answer questions as well. Mr. Daly.
Thank you, Senator Harris. Good afternoon. My name is Chris Daly. I'm Deputy Director for the Nevada State Education Association. Thank you, Senator Dennis and members of the committee for hearing Senate Bill 224 this afternoon. And of course, thank you, Senator Harris, for your sponsorship. SB 224 is a somewhat technical bill, but it is fundamentally about fairness in the employee reassignment process in the Clark County School District. While I'll provide some background now, I am joined, Senator Harris said, by our counsel, Sue Matuska, to provide additional legal background and to help present the language and purpose of the bill. In 2017, Assembly Bill 469 reorganized the Clark County School District, decentralizing much decision-making authority to individual schools called local school precincts. Language in AB 469, now in NRS 388G, transferred the authority of the superintendent to select staff who work under the direct supervision of the principal to the local school precinct. This language has caused confusion for both the district and ESEA, the Education Support Employees Association, representing education support professionals, or ESPs, in the Clark County School District. We believe it was never the intent of the sponsors of AB 469 to override contract language on the issue of employee reassignments. Unfortunately, a 2017 Attorney General opinion disagreed. as negotiated between the Clark County School District and ESEA in 7 pages of contract language. The reassignment process related to surplus situations or a reduction in force allows the district to determine appropriate staffing levels and adjust these levels at any time while providing a fair process for impacted employees. ESPs with the lowest seniority in their position go through the surplus process when schools can no longer afford or no longer need their position. This process has nothing to do with job performance. Last fall, acting on that 2017 opinion, CCSD began requiring education support professionals to interview with a school principal as a part of the surplus process, impacting over 50 ESPs. Several ESPs were rejected for a lateral position through no fault of their own at an individual principal's discretion. This created an untenable situation for these workers who were still technically employed, but without a position. Fortunately, a decision by the MRB in December remedied the situation, but is now subject to litigation. Meanwhile, serious questions of racial bias were raised during this new surplus process. As stated by one ESEA member who works as a special education aide, quote, "I was asked to leave through no fault of mine. I'm a 15-year employee looking to be placed in a lateral position. After going through the process, I was required to interview, which was extremely uncomfortable. I felt like the principal and the team were discriminating based on my race and dreadlocks. They did not tell me I had the lateral position when I left. I've already passed probation, have proved myself in the district. Yet because my current site can't afford me, I have to interview all over again? I got rejected twice. Why should I stay a special education aide if this is how I will be treated?" End quote. So if it is okay with the chair and the bill sponsor, I would like to now turn the presentation over to Sue Mateska of the law firm Dyer Lawrence. Thank you.
Yes, go ahead. Welcome, Ms. Matuska.
Thank you. Thank you, Senator Harris and Chair Dennis and members of the committee. My name is Sue Mateska. I'm an attorney with the Dyer Lawrence Law Firm in Carson City, and I'm here today representing NSCA and ESCA on SB 224. As Mr. Daly was saying, the impetus for this bill is a disagreement that's developed between ESCA and the other unions that represent employees of the Clark County School District, as well as with the district itself, on the meaning of subsection 2 in NRS 388G.610, which is the section amended in this bill. This section was created as part of the reorganization bill in 2017, and that bill designated every school in the district as a local school precinct and gave them more authority over their budgets and choosing their staff with their budgets. But the district remained the employer in that bill, and of course remains the employer today. The bill also specified that the district remained responsible for all other responsibilities that were necessary for the operation of the district and the local school precincts, and specifically remained responsible for negotiating on the mandatory subjects of bargaining, which are set forth in NRS 288.150. And the reorganization bill did not amend 288.150, nor did it even reference it. So, as said, there's been this disagreement, and the legal background is that that has resulted in one matter before the Employee Management Relations Board seeking a declaratory ruling on the interplay between this section 388G.610 and NRS 288.150. The board did issue an order indicating that these sections could be read harmoniously and that the reorganization bill did not intend to strip rights from employees. However, the board has indicated that that's not a final decision and that further orders could be issued. There has also been a matter filed in district court in Clark County, a writ petition seeking specific actions be taken by the district or that specific actions be prohibited. So that is also out there. And clearly there's still a disagreement. This matter hasn't resolved itself. NSCA and ESCA believe that this bill will clarify the original intent, particularly for support staff. Staffing adjustments necessarily occur from time to time, and they historically occur more for support staff than other employees. This is one of those things that is the necessary operation of the district and the local school precincts. And it just makes sense that the district would be responsible for these kind of surplus shifting of assignments of employees, because after all, for one particular surplus situation, it might not even affect a local school precinct over here or over there. You need to have the district up here responsible for these arrangements. And we believe, again, that that was the original intent. So the bill and the amendment that's been, I believe, sent to all of you adds a new subsection 3 just to clarify that regarding the transfer of authority to select staff. It's not intended to apply to matters that have been negotiated in collective bargaining agreements for support staff, or the responsibility to comply with those terms of the collective bargaining agreement. And then the other thing that's in the bill and the amendment is a definition of what is a surplus situation. And that would be anytime the services of an employee are no longer needed at a particular location because of changes in pupil enrollment, changes in pupil staff allocation formulas, reductions in force or layoff situations, or just overall changes in academic needs that require these kind of adjustments. So that runs through the bill and the amendment language. I'm happy to answer any questions if that would help.
Okay, so let's, anybody have any questions? Yes, Senator Lang, and then Senator Buck.
Sue, this is Senator Lang for the record. I wasn't tracking maybe because I'm not feeling good, but did you say, what was the background information on having to reapply all the time? Was that part of the reorg? And are you looking to get rid of that language, or you know what?
The reassignment process, you mean?
How they have to do an interview with the principal.
Right. So I think Mr.
Okay, so
Daly
when
might.
you answer, excuse me, Ms. Matuska, whenever you respond, you need to put your name. So on the record, it's clear who says what, who said what.
Thank you,
So-
Chair Dennis.
So Sue, you want me to try on this one?
Yes, please.
If I could, Chris Daly, Nevada State Education Association, through Chair Dennis, to Senator Lang. In a surplus process, I referenced pages of language in the negotiated agreement between ESEA and the Clark County School District. It's a relatively involved process, a lot of notice. There's a surplus meeting. Employees who are surplused then basically have positions that are vacant that they can make a lateral transfer into. There are steps to that. What the Clark County School District added to this pretty involved process per that 2017 Attorney General's opinion when they did the surplus process last fall was the requirement that after you go through all of this, you then also have to interview with a local school precinct, typically a principal at one of those local schools, who then has the individual discretion to either hire or not hire. And what we found was that a number of ESPs who went through this process were unable to get hired, even though they had stellar work records, nothing in their files. Just an individual principal decides not to hire that person. We had a number of folks last December who were in the position where they're employees of the Clark County School District, but they did not have a position, orphaned within the system because of that requirement. The EMRB decision remedied that, but as Ms. Matuska stated, it's not a settled issue. And so we wanted to bring this bill. Appreciate Senator Harris for bringing it to bring clarity to the situation. And, to say that the contract with regard to employee reassignments in a surplus situation or reduction in force, that the language from the CBA speaks.
Thank you.
Thank you. Senator Buck.
Thank you, Chair Dennis. So SB 120, holds principals accountable. And I'm a little worried about, because I know I sat in the principal seat for some 15 years, and that being in the Clark County School District. And I've had people dropped into my lap that weren't aligned to the vision. And this was not based on race. And I'm actually disgusted at the allegation of that when there's no data to support that. But from my understanding, there's pending litigation in this, and I'm just wondering, when is that hearing scheduled?
For the record, this is Suma Tuska, attorney for NSCA and ESCA. So there's briefing still going on in the district court action, and there's a hearing on it scheduled for, I believe it's April 22nd. Parties are moving to dismiss that, and the board has stayed its proceedings for now. That's the Employee Management Relations Board has stayed its proceedings for now, and that's the current status.
Chair Dennis, if I may have a follow-up.
Yes, please.
Thank you, Chair Dennis. So I guess that's my gravest concern, is that there's pending litigation for this, and there's little to no data that it's based on certain aspects that are allegations that you're stating. And so I don't see how we can hold no school or business or anyone in their right mind would just place people in buildings' laps and just hope for the best. You have to have a mutual agreement to it. And so that's my 2 cents. Thank you.
If I could, Senator Dennis, Chris Daly, Nevada State
Yes,
Education
please.
Association, through Chair Dennis, to Senator Bach. I think it's fair to have a concern about principals who have responsibility and are being held accountable for the performance of their school. At the same time, I think that also needs to be balanced with, 15-year employees who have, no bad marks on their record through no fault of their own, working oftentimes at the same school site for years and years, but the district has the ability to change, the number of positions at that site. And if you end up in the surplus process through no fault of your own, and then you have to basically re-interview for positions, if you end up not getting a position for whatever reason or for no reason at all, you're basically out of a job, or at least out of a position, even if you're still technically employed. And so we think that the language as negotiated between the school district and ESEA, which is significant in terms of employee reassignments, is language that has worked well. I would say that the amendment, which more narrowly tailors the application of this to education support professionals. So, potentially, custodial staff, potentially food service staff, potentially, classroom aides. That this is fair legislation to move forward and to rely on, the negotiated agreement between the district and the Employees Association. I would also point out again that we believe that it was the intent of the authors of AB 469 for this to be the case and for there not to be that discretion on employee transfers or reassignments.
Mr. Daly, when someone is surplused and then they are not picked up by another school, are they eligible for unemployment?
So no, I would think that they would not become eligible for unemployment until their employment is terminated formally. That potentially could happen further down the road. My reading of and Sue might have a better reading of the contract or maybe the district, but since the MRB opinion remedied our situation in December, we didn't have to go down that road. But I imagine if someone was not picked up through the surplus process, they would go to the RIF, reduction in force process, and then, eventually they could end up just out of work or severed from the district. At that point, they may be eligible for unemployment, but not while they are employees, I wouldn't imagine.
So if they're not picked up, though, that means they're not working anywhere, so they're not getting paid, right? But they're still employees of the district. Is that?
That is my understanding.
Okay. Other questions, Senator Buck?
Thank you, Chair Dennis. So we always tout that we are about children first, and we're short, 10,000 teachers. I know at least 2,000 teachers in our state. And so it's really hard for me to believe that with all of the different openings that somebody is not picked up. And if they're not, are they bad for children? Because we need to put kids first. And so I'm just wondering I understand that you're about the adults in the system, but when somebody is bad for kids and somebody's not being picked up by multiple principals, something could be wrong. So do you help coach and mentor, or do you just, find a place for them and hope for the best?
Through Chair Dennis to Senator Buck, Chris Daly, Nevada State Education Association. NSEA has advocated for professional development programs for education support professionals. We do provide some professional development. In this situation, though, I would just like to point out again that a surplus process or a reduction in force process happens when the district is basically moving positions. It does not have to do with the performance of the employees who end up in the surplus or RIF process. They tend to end up there based on seniority and just happenstance in terms of, a new school opens or, there's student enrollment shifts or there are budget cuts or that sort of thing. So, we believe that our members do work in the best interest of students. We, Senator Buck, are also student focused. Most of our members work in education. A lot of our education support professionals aren't at the higher end of the wage scale. So most of our members work in public education because they care about kids. And so, we are student centered. In this case, this is a more technical issue and one that involves some bureaucracy. But in the process that happened last fall, we did believe there was an issue of fairness, and we believe that the negotiated language in the contract, which is extensive, is the best process to move forward. And we also believe that that was the intent of the sponsors of AB 469 in the 2017 session.
All right, are there any other questions? Okay, let's go then to testimony. We're going to hear, we're going to go to testimony in support. Actually, before I do that, real quick, Senator Harris, any additional testimony or others that you want to present before we go to that?
No, that would conclude our presentation, Chair Dennis. Thank you.
Great. All right. Thank you. Yeah. So let's go to those wishing to give testimony in support. Reminder, 2 minutes, and I'll give a warning right before the end there, so that we can stick to our time frame. And I want to go. Let's say let's do 15 minutes for each one, no more than 15 minutes. So if you are giving testimony and the person before you just gave testimony, it's okay to say ditto. And also you can submit your testimony in writing. So with that, let's go to those in support.
Thank you, Chair. To testify in support on SB 224, please press star 9 now to take your place in the queue. Once again, if you'd like to testify in support on SB 224, please press star 9 now. Caller with the last 3 digits, 536, please slowly state and spell your name for the record. You have 2 minutes and you may begin.
My name is Jason Gately, JASON-GATELEY, Vice President, Teamsters Local 14. Thank you for allowing me to speak in support of SB 224 and the education support professionals with the Clark County School District. When the legislature created NRS 388, it did not make Nevada's collective bargaining law, NRS 288, secondary to the unilateral actions of school principals. There is very clear language in the contract between CCSD and the ESEA, which provides a surplus process and placement for unassigned staff. SB 224 reinforces the requirement within the text of NRS 388 through unilateral actions by administrators, support professionals now find themselves exposed to potential age, gender, and racial discrimination when staffing decisions are being made at local schools. We ask for your support to ensure contractually agreed surplus process is followed. Thank you for your time.
Thank you very much. Let's go to the next caller.
Caller with the last 3 digits, 402, please slowly state and spell your name for the record. You have 2 minutes and you may begin.
Good morning. My name is Terry Schuman, SHUMAN, and I am speaking in favor of SB 224. Surplus can be devastating. Many times when the employee cannot get a lateral position, it means a loss of pay, months, and hours. In my very first surplus, I was forced to go from a level 50 down to a level 44. I lost close to $500 a paycheck. I had very little seniority, so there was nothing that I could do. Seniority used to be the key that support professionals wanted in their hands when it came time to surplus. If you had seniority, then you could take the positions that was lateral to the position that you were being surplus from. Without seniority, surplus ESPs would have to choose or be placed into positions that were lower and nobody else wanted. When AB 469 came to be, seniority was replaced with administrators who were interviewing and hiring employees who they wanted in their school. This ended up with higher seniority employees ending up with lower paying positions. After our EMRB held a hearing, they rejected the idea of principals holding interviews. What I'm asking you to do today is pass SB 224 into law so that those support professionals who have seniority, those who have spent the most time dedicating their time and talents inside CCSD will be able to use their seniority to get the better positions. Please vote yes on SB 224. Thank you.
Thank you. Let's go to the next caller.
Caller with the last three digits, 232. Please slowly state and spell your name for the record. You have 2 minutes and you may begin.
Thank you. Good afternoon, Chair and members of the committee. For the record, my name is Jan Giles, Jangiles. I am the president of the Education Support Employees Association, otherwise known as ESEA. ESEA represents education support professionals, otherwise known as ESPs, throughout Clark County. ESEA is speaking in support of Senate Bill 224. In 2017, Assembly Bill 469 reorganized the Clark County School District, transferring much decision-making authority to individual school precincts. The language stated each local school precinct should have the authority to select staff who worked under the direct supervision of the principal. For the past several years, the language has caused a lot of confusion for both the district and the education support professionals, with conflicting language on transfers and reassignments and existing contract language. ESEA has maintained it was never the intent of AB 469 to override contract language on this issue. Unfortunately, in 2017, an opinion issued by Attorney General Laxalt disagreed. Previously, the surplus process in CCSD allowed the district to balance staffing needs with decreased student enrollment. ESPs were with the lowest seniority in their position went through a surplus process with the schools could no longer afford their positions. This process had nothing to do with the job performance. While the surplus process was successful for the employees, nearly everyone was placed in a new position at the end of the day. Last fall, relying on the 2017 opinion, CCSD began requiring ESPs to interview for a school position as part of the surplus process. Over 50 ESPs went through this new process, and several ESPs were rejected for a lateral position through no fault of their own at the principal's discretion. Serious questions of racial bias have been raised in this process, setting CCSD back on its goal of diversity and equality. The issue was heard before the EMRB on December 7, 2020. They issued a decision rejecting the 2017 Attorney General's opinion, as well as various arguments regarding the authority held by the principals in a surplus or reduction.
I need you to finish up.
Okay, thank you. So I just wanted to say that we urge you to pass SB 224. Thank you.
Thank you. Let's go to the next caller.
If you have recently joined the call and would like to testify in support on SB 224, please press *9 now to take your place in the queue. Chair, there are no more callers in support at this time.
Thank you. Let's go to those in opposition, those wishing to give testimony in opposition.
To testify in opposition on SB 224, please press *9 now to take your place in the queue. Caller with the last three digits, 517, please slowly state and spell your name for the record. You have 2 minutes and you may begin.
Good afternoon, Mr. Chairman. My name is Danny Thompson. I'm here today representing the Clark County School Administrators Association. I would like to express our opposition to SB 224. Specifically, I'd like to inform the committee that this bill is directly involved in an ongoing lawsuit. In fact, the issue is scheduled to be heard in district court in Las Vegas on April 22nd. Because this bill will decide the winner of that ongoing lawsuit, the bill should be set aside until the judge has ruled in that case. Historically, the legislature has avoided issues that are actively before the court, not just because the separation of powers amongst the three branches of government, but because the precedent that you would be establishing. Once you start settling active lawsuits, then everyone will come to you and expect you to settle their issues before the court. I understand the legislature has broad powers when it comes to writing the law. However, this power is called into question when you are involving yourself in active suits. With that in mind, there is an inherent problem with this issue, as if you pass the bill, you will be putting yourself as the judge and jury in a separate branch of government. Because of that, if you decide to proceed with this issue, each senator who votes on this issue must ask themselves if they have a special interest in the outcome. So, for example, if a senator has taken a campaign contribution from either side of the issue, you should declare a conflict on the bill and abstain from voting on the issue. Otherwise, you are putting yourself in a position to be challenged with an ethics complaint. After the court has exhausted its processes, the issue can be taken up by the legislature and changed the way you see fit. For these reasons, we ask you to set this bill aside until the court has ruled, and if not, then we ask you to vote no on SB 224. Thank you.
Let's go to the next caller.
Caller with the last three digits, 745. Please slowly state and spell your name for the record. You have 2 minutes and you may begin.
Chair Dennis, members of the committee, my name is Stephen Augsburger, and I'm the Executive Director of the Clark County Association of School Administrators and am speaking in opposition to SB 224. In 2017, the Nevada Legislature decentralized the Clark County School District and transferred critical decision-making to local school precincts in the areas of budget, purchasing, and staffing. In other words, the 2017 law requires that important decisions that impact the school are to be made at the school site by the principal and school organizational team. Contrary to current law, Senate Bill 224 seeks to greatly restrict the local school precinct's power to select their own staff by making that power subordinate to various collective bargaining agreements. Clearly, SB 224 undoes what the legislature accomplished in 2017. Local school precincts only want to hire the very best employees. Senate Bill 224 takes that authority away and gives it back to the Clark County School District and its teacher and support staff unions. Senate Bill 24 will perpetuate the dance of the lemons and ensure that poor employees are forced placed into schools. In truth, CCSD has never abided by the law and continues to place poor employees in schools against the wishes of the local school precinct. As a result, school administrators filed a lawsuit against the CCSD in October 2020. This lawsuit will be heard in district court on April 22nd. In closing, principals ask that education policy favor children and not the CCSD, whose primary interest in this matter is looking out for the interest of adults. Principals also ask that because this matter is currently being litigated, the legislature honor its longstanding practice of not interfering in pending litigation. And finally, because the reorganization legislation has the ability to greatly improve achievement for children in CCSD, principals ask that this school improvement legislation remain unchanged and be given the opportunity to achieve its intended results. Please vote no on Senate Bill 224. Thank you.
Let's go to the next caller.
Caller with the last three digits, 090. Please slowly state and spell your name for the record. You have 2 minutes and you may begin.
Good afternoon. For the record, Chelsea Capurro, CHELSEA-CAPURRO, on behalf of the Nevada Association of School Administrators. We are opposed to SB 224. This bill prioritizes the needs of employees over the needs of Nevada children. Our children deserve more. They deserve to have a great teacher. If passed, this legislation will place poorly performing employees without the consent of the school principal, as this legislature has decided is the best policy for students. The Clark County School District has taken the position that union contracts must be followed in spite of the staffing autonomy provided to principals and schools in NRS 388G. Because of CCSD actions, school administrators have filed a lawsuit in district court to resolve this matter. The district court judge has scheduled the hearing in this matter for April 22nd. The Nevada Legislature has a long history of not getting involved in lawsuits. The content of SB 224 is at the heart of the lawsuit. Hearing this legislation could cause the district court to once again delay the court proceedings. Again, we are asking that the needs of Nevada children and what is best for them in the classroom be placed above the needs of poorly performing employees. Please let this be decided in district court and do not pass this bill. Thank you for your time.
Go to the next caller. Just want to remind folks that if it's already been said, it's okay to say ditto.
Once again, if you'd like to testify in opposition on SB 224, please press star 9 now to take your place in the queue. Chair, there are no more callers in opposition at this time.
Thank you very much. Let's go to those in neutral.
Thank you, Chair. If you would like to testify in neutral on SB 224, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 000, please slowly state and spell your name for the record. You have 2 minutes and you may begin.
Good afternoon, Chair Dennis and members of the Senate Committee on Education. My name is Bruce Snyder. I am the commissioner of a state agency called the Government Employee Management Relations Board, more commonly known as EMRB, which regulates labor relations between Nevada's governments and the employee organizations that represent their employees. I offer my comments in the neutral position. About 1 year ago, the Clark County Education Association filed a complaint with our board. Subsequent filings involved a counterpetition for declaratory order filed by the Clark County School District, as well as motions to intervene filed by CCSD Support Staff Union and School Administrators Union, both of which were granted. So all 4 parties to the case agreed that the EMRB should first rule on a counterpetition, which asked the board to provide guidance on how to harmonize the duty to negotiate under NRS 288 and the provisions of the school code creating school precincts in Clark County. The board issued its order on the petition in December 2020, stating it could only speak on NRS 288, as it had no jurisdiction to rule on other chapters of NRS. However, the order states that NRS 288 provides for mandatory subjects of bargaining, and that NRS 388G 610, which is at issue here, and NRS 288 150, which provides the list of mandatory subjects of bargaining, are not in conflict, and that the statutes can be interpreted to render a harmonious result without infringing on NRS 388G 610 rights. As I read this bill and the proposed amendment, they both appear to codify the board's interpretation of NRS 288 and the board's harmonization of the 2 statutes at issue. Finally, I note that our board has since stayed the case as it learned that there is a matter pending in the 8th Judicial District Court by the same parties seeking the court's interpretation of NRS 388G 610, of which, as previously mentioned, the EMRB has no jurisdiction. Thank you.
Yeah, thank you. Let's go to the next caller. We are in neutral. Go ahead.
If you have recently joined the call and would like to testify in neutral on SB 224, please press star 9 now to take your place in the queue. Chair Dennis, there are no callers in neutral at this time.
Great, thank you very much. Okay, let's go back to Senator Harris. Any closing comments?
No, I'd just like to thank the committee for their time. I know this is the very last day, and I appreciate everyone giving us some consideration.
All right, thank you very much. With that, we will go ahead and close the hearing on SB. Yes.
I was just wondering if legal could respond to the legal questions that have gone back and forth about whether the legislature can do anything until the legal thing is resolved. I just would be interested in hearing what legal has to say.
I think we have Mr. Killian on the line with us.
Thank you, Chair Dennis. Chair Dennis, Asher Killian, Committee Record. So generally, it has been the past practice of the legislature in some cases not to consider legislation when the subject matter of the legislation is currently subject to litigation. However, the legislature has plenary power to consider laws in any respect for the state, and especially in a case like this, where the question at issue is the legislature's intent in the interpretation of particular statutes. The legislature is free to act to clarify that intent regardless of whether it would moot the litigation at issue or not. So in other words, when the question before the courts is what the legislature intended, the legislature is always free to then act to make clear what its intent was.
Thank you.
All right, thank you. All right, with that, I'm going to go ahead and close the hearing on SB 224. Let me change my paperwork here for a second. Okay. All right. All right, we're going to have a work session now, so we're going to begin. I know that we've, with the way that the session has gone, there's been a lot of, had to make a lot of change to different bills. So we're going to be hearing some bills today, and they've got amendments on them, and this is our opportunity to ask questions, see where we're at and how we feel. So if we could go to Ms. Sturm.
Thank you, Mr. Chair. Jen Sturm, Committee Policy Analyst. Again, as nonpartisan LCB staff, we do not advocate for or against any legislation. So the work session documents may be found on Nellis for those who want to follow along. And I will now walk through the 8 bills currently on work session, beginning with Senate Bill 102, which is sponsored by Senator Hammond and heard on March 15th. The bill changes from September 30th to August 1st the dates by which a child must be a certain age at the beginning of a school year in order to be admitted to certain grades. Senator Hammond proposed 2 amendments to this bill. The first is to change the effective date to upon passage and approval for purposes of adopting regulations, and then on July 1st, 2022 for all other purposes. And the second amendment proposed to change the cutoff date from August 1st to August 7th. Mr. Chair.
Okay. Senator Hammond, do you want to address any of the issues? I know there's been some amendments and you've changed some things. If you want to talk about that.
Yes, thank you, Mr. Chair. Yeah, the 2 overarching concerns, so there's 3, but then one of them we could not address fully with discussions with the district, but one of them was the implementation. The worry was implementing it this year would cause the heartaches, especially since they do a lot of registration before that time. So we changed the effective date until next year so they can ramp up and get ready, move personnel as they need. The second one was a suggestion from Senator Loop, instead of being August 1st, moving it to August 7th, which still would be right before school begins. I thought it was a good suggestion. So I find that a happy and friendly amendment. And then the third one that we tried to work on was trying to figure out a way for those who are 4th graders, how do you get them in if they are ready? And the school districts just did, we had a hard time trying to wrap ourselves around language that would accommodate that. And just couldn't come to that. But we'll keep thinking about that later on as well. But those are the 2 amendments that we put in there into the bill that changed it.
Chair.
Yes. Senator Loop.
Thank you, Chair. I just need to clarify something. I never suggested August 7th. My suggestion is we don't do this at all. As a 30-year teacher, as a kindergarten teacher for 10 years, as a person who has watched kids come and go, there's always going to be a younger child. There's always going to be an older child. And we have a lot of parents who seek daycare, for example, so this will put that off a year. We have children who are older, who are very immature. We have children that are very young, that are very mature. Some of that is family structure. Some of that is where you're placed in the family. But I just cannot support this bill in good conscience, because I think that at the end of the day, we are going to change the date, and then the date on school is going to change again, and then we're going to change it again, and we're just going to keep changing. We're just going to keep drawing lines in the sand. And if we're going to vote for this, are we going to vote for mandatory kindergarten and pre-K? And where are we going to fund it? So if Senator Hammond can tell me that he'll support mandatory kindergarten and mandatory pre-K, which he's voted for or voted against in the past, and funding for that, then maybe I'll talk. But I haven't had that conversation with him, so I don't know where that came up. Thank you.
Mr. Chair, if I could.
Yeah, go ahead.
No, and my apologies. I was led to believe that that was a suggestion that came from you in my discussion with the chair when he said that there were 3 possible amendments that he'd heard about. So perhaps we were just misled there. But I'd love to have a discussion on other stuff later on. But you know, the bill at hand is this one right here. If you want to vote no, I completely understand. Thank you.
Other questions? Senator Donate.
Thank you so much, Chair Dennis. Senator Hammond, do you happen to know how many children may be impacted by this change in date? So for instance, this is a number of students that qualified this time, but because we're moving back the date, this is a number that we have right now that we think may be impacted, and we'll have to wait until the following year.
Thank you, Senator Hammond. For the record, through you, the chair, to you, Senator Donate. I don't know exactly how many. When I talked to Clark County, their estimate was around 3,000. That was before the change from August 1st to August 7th. I would imagine that the person I heard from, he probably would know all the, with the change, if we go into August 7th, they probably have the numbers, but it would probably be less than that now. And then Washoe County, I do not know. I would imagine that Ms. Anderson would have that number at some point, and I can get that to you. I'll just ask those 2 counties, and then I'm not sure how it would affect the smaller counties.
Thank you.
Do we have any other questions? Senator Hammond, can you just remind us what the main premise of this bill was? That we've got kids that are in class for, I guess, 2 months since school starts. I mean, why is that such an important thing?
Sure. So when this was brought to my attention, it was a couple of principals, and then I've spoken to kindergarten teachers since, and what they said was that with the change when we start school, we have 4-year-olds in school for about 2 months, up to 2 months. And a lot of them are just simply not ready for school, which means when they evaluate and they try to figure out where the student is, many of them are placed on that Read by 3 program, where now they are, they need extra help for, those however many years until they get to 3rd grade, which then puts a burden on the school system itself. And so just by moving it up and making sure that everybody's at 5 years, and I get someone's going to be older, someone's going to be younger, and that's absolutely true. It's not that we're trying to change that we can't change that. What we're trying to do is making sure that no matter who is younger, who is older, that they're all ready to, as many as possible can be ready for school when they get into school. And that's the issue we're trying to solve.
Okay. All right. Well, because we're where we are, I think that there's still probably some issues and some questions. I'm willing to vote for it today, but I still have some reservations, and maybe that's something that you can work on, and as we move forward. But I still have questions. Other discussion from members? Okay, so what's the will of the committee?
Amend and do pass.
Senator Buck has a motion to amend and do pass. I'm not hearing a second.
Second.
We have a second from Senator Lang. Discussion. Yes, Senator Donate.
Thank you so much, Chair Dennis. Yeah, the only thing that I wanted to mention, I asked that question specifically as to how many students were going to be impacted, because, you know, as I heard the bill hearing and, you know, within the past few days, I reread the bill, and, you know, at first glance, it didn't really jump out at me as concerning. Up until probably the last few hours, when I realized, you know, every time we make a decision that impacts kids' education, especially at that early age, that means that we start to have the conversation of students that might be left behind. And when we start to change cutoff dates, that can have ramifications for especially working class parents who might not have access to pay for early education. And when I hear the talking point, not ready for school, I don't know if that's a conversation of immaturity or if it's what I think principally lack of access to early education, which is what Senator Dondero-Lupe, Vice Chair Dondero-Lupe was getting at, which is we really need to focus on funding early childcare, access to pre-kindergarten, because that is what I think of when we use the term not ready for school. So I'd like to have that as a conversation. I will be voting yes for this, but I will reserve my right, and I might change my floor vote. But that's what I hope that we can get out of this, and that we can support working class families who might not be able to afford childcare because we're changing a policy as to when students can be enrolled.
Thank you. That's a valid concern. Other discussion? Okay, let's go to the roll call vote. Are we missing Senator Hardy? Oh, no, he's here. Okay. If we could go to the roll call vote.
Vice Chair Dondero-Lupe,
No.
Senator Hardy,
Yes.
Senator Hammond,
Yes.
Senator Lang,
Yes, and I reserve my right.
Senator Buck,
Yes.
Senator Donate,
Yes, but I reserve my right.
Chair Dennis.
Yes, and as I mentioned before, I also reserve my right. I just to be able to resolve some of those issues. Okay, the motion passes. Let's go to the next bill, Senate Bill 120.
You, Mr. Chair, Jen Sturm, Committee Policy Analyst. The next bill is Senate Bill 120, which is sponsored by Senator Dennis and heard on April 7th. The bill makes principals at will for the first 3 years of employment. After those 3 years, a principal may be placed back on at-will status in certain circumstances. The bill also requires certain administrators in post-probationary status to apply for reappointment, and if not reemployed, the administrator is entitled to be reassigned. Senator Dennis proposed the following amendments, and those should be attached to the work session documents. The first one is to remove the school rating factor in subsection 2A of section 2. 2, amend subsection 2B of section 2 to clarify that 50% of teachers must transfer rather than request a transfer to trigger the at-will status of a principal, and similarly amends section 3. Number 4, require confirmation by a supervisory investigation that school conditions are a factor if the survey indicates school climate was an issue, in which case professional development would be required of the principal. The next proposed amendment is to require confirmation by a supervisory investigation that 40% of teachers transferred due to school climate issues. And then the next amendment would be to provide an exception from the post-probationary at-will employment status and teacher survey provisions for certain principals who have been placed at underperforming schools. Next, it would require certain principals placed at underperforming schools to take school climate training within the first year. Number 8, the proposed amendment would remove the requirement that central office administrators reapply to their position every 5 years. The next amendment would be to include administrators in the list of personnel in which certain Nevada revised statute provisions concerning evaluations, probationary and post-probationary employment, and disciplinary action do not apply. Next, it would provide that every year, each school district must develop a plan for professional development of administrators to include non-binding principal to supervisor ratios. And finally, items 11 and 12 speak to the submission and reporting requirements related to professional development. Mr. Chair.
Thank you. So after the hearing the other day, there was some folks that were opposed, and they brought up some very valid points and had some discussions, and that's where some of these additional amendments came forward. We had a few people that asked about the issue of administrator had been crossed out. So in this amendment, you'll see that that's put back in. That gives the ability for the administrators to negotiate the discipline. In addition, the other changes that were made was where it talked about teachers, instead of just submitting to transfer, they have to actually transfer. I think that's something that somebody had brought out. So we worked on these. I think that in fact it was I worked with the administrators because of some of their concerns, and these were some of the things that they brought back that they had mentioned that they would be able to be in support if those things were fixed. I think what we have today is a much better bill than what we started out with. I think it helps administrators. I think it also helps school districts to make sure that that training is going on, and it provides that they get to report on the type of training that they're doing, and that's a really good piece in this. And with all the other changes, I think that there's some pieces here that will really help administrators to be better. And there's still the incentives to be able to go to at-risk schools, in which we don't want to disincentivize. We want to incentivize principals to be successful. And so I think that with the amendment, with all of the amendments that have been put in, I think it's a much better bill today, and it helps actually provide some tools for administrators and for teachers, and as we move forward. So with that, questions? I know you didn't see all of these amendments the other day because there's some new ones. Senator Dondero.
Yes, I'm a little concerned because I haven't seen these amendments before. And so we're sort of, voting on the fly. Who was involved again in constructing these amendments? Was it just you, or was there somebody else?
So these were the most recent ones. I worked with Danny Thompson and the association that he represents of administrators. And I know that they voted on these amendments, both from in the Washoe County and Clark County associations. So the most recent ones that you're just seeing today for the first time, those are coming from them.
So are they on the line? Can they confirm that with us? That the administrators have been involved and have voted on this?
I don't know if we've got anybody from. We don't have anybody online. But what I would say is, if you have questions, we've been doing this for the last couple of days in all the committees. There's changes because of the way that things are working out right now. Sometimes it's hard to get everything all put together, but I know that we can get that if we need that. We don't currently have them online. So, Senator Buck.
Thank you, Chair Dennis. So I often think that it's sort of ironic that we put more bureaucracy on building leaders in big systems. You're the very people that wonder why charter schools have more autonomy and build, and we actually in this legislation are building less autonomy into a system that's really overburdened and really at our mercy with this. And so do you not trust the process of the system in which, you know, supervisor, coaches, teach or train leadership? Do you not trust the process to provide due process to employees?
So this bill came forward because there are issues. When I ask about training and other things, you know, there is some issues when it comes to some of the training for principals. That's, you know, and this bill will address that to ensure that the principals are being trained. One of the results, you know, we in Clark County School District, we have a 1-to-31 ratio of superintendents to principals. As a result of this bill, the school district is going to be adding some more some supervisors because they realize that that needs to happen. So I think there's some good things that have happened just because of this. I think that we've put in place now by working with administrators and teachers. There's some good pieces in here that will actually help them, and they still have the ability if they've got several abilities here. One is you can have an agreement with the school district when it comes to if you're going into an at-risk school, which would bypass these things. Also, the administrators have the ability to negotiate that discipline if, you know, that would be different than what's here. So I think there's a lot of flexibility in here for administrators and for districts to be able to do the things that we need to provide the best leadership that we can in schools.
Chair Dennis?
Yes, Senator Lang.
Danny Thompson is on the phone lines. If you want to call in and he can answer the senator's question.
Thank you. Do we have the ability to connect him in? BPS?
Stand by, Senator, and we will check with our public comment line. Just one moment, please.
Hi, Chair Dennis, this is Broadcast. What are the last three numbers of Danny Thompson's phone number?
I do not know. Hold on.
If Mr. Thompson is in the call, please press *9 to take your place in the queue. Caller with the last three digits of 517, Mr. Thompson, if this is you, please proceed.
Yes, thank you. Yep, Mr. Chairman, to the questions, we did meet with you and agree to all the changes that have been outlined in the amendment. And that was not just Clark County and Washoe County, that was statewide administrators.
That sounds like Danny Thompson's voice.
Yeah. Yeah, thank you. Ms. Dondero-Loop, or Senator Dondero-Loop, does that answer your question?
I just feel like I haven't had enough time to process all this, so I probably will be a no and reserve my right. Just so I can, you know, have some time to study this.
Okay, thank you. Any other questions? Okay, what's the will of the committee? Senator Donate.
Motion to amend and do pass.
Thank you. We have a motion to amend and do pass. Do I have a second?
I'll second.
Second from Senator Lang. Any further discussion on the motion? Let's do a roll call vote.
Vice Chair Dondero-Loop,
No, and I reserve my,
Senator Hardy,
No.
Senator Hammond,
I'll be a no.
Senator Lang,
Yes.
Senator Buck,
No.
Senator Dunyate,
Yes.
Chair Dennis.
I believe that was 3 yeses and 4 nos. Is that correct?
That is correct, Mr. Chair.
Thank you. Motion doesn't pass. Okay, let's go to the next one. Senate Bill 126.
Thank you, Mr. Chair. Jen Sturm, Committee Policy Analyst. The next bill is Senate Bill 126, which is sponsored by Senator Dondero-Loop and was heard on April 5th. The bill relates to school libraries. The measure requires each public school in certain counties to have a library that provides services to students and staff and to employ a teacher librarian. These requirements also apply to certain large charter schools. The bill creates an exception to the requirement to hire a librarian under certain circumstances and allows school library assistants to meet the requirement until July 1st of 2027. The minimum requirements of a school library will be established by the State Board of Education through regulation. And there are a couple amendments listed here for the committee's consideration. And the first, and those are attached, of course, to this work session document. The first would amend the school library assistant's description to include a person who has successfully completed an alternative route to licensure program for paraprofessionals. 2, the proposed amendment would delete the required number or required minimum square footage for a school library established within each public school in certain counties, and to instead require the State Board of Education to prescribe the type of facility and amount of space needed, including at minimum a designated space accessible during school hours. And the third amendment would amend Section 10 to reflect the certification process for teacher librarians through the Department of Education by deleting the certification issued by the National Board for Professional Teaching Standards and replacing that with the certification issued by the Department of Education. Mr. Chair.
Thank you. Senator Dondero-Loop.
I'm here with, if you need additional questions. This bill was in partnership with not only the librarians, but the Clark County Education Association. And I urge your support. The amendments that are here were submitted by the Librarian Association. Thank you.
Any questions on the bill? Yes, Senator Buck.
Thank you, Chair Dennis. So we kill funding to Read by 3 that showed results for once in the past 2 decades with now mandating an archaic system of librarian and library. And so what I'm wondering is, how does this transcend this to, I mean, because we've done this in the past and it never changed student achievement. So how is this going to transcend to ensuring that kids can read?
Thank you for the question, Senator Buck. Marilyn Dondero-Loop for the record. First of all, I would argue archaic is a little bit interesting word, only because libraries are still happening in communities. People need access to computers. People read online all the time, and they go there for assistance with research, and that's what librarians teach, along with a host of other things. We could suggest that schools don't need principals. We could suggest a lot of things, and we didn't kill funding for Read by Grade 3. We, last session, with Senator Dennis and Senator Woodhouse and others, created a new funding formula that's a pupil-centered funding formula to replace the archaic, which that is a perfect word for that, a 50-year-old funding formula. So with this being said, we are advocating that we have somebody within a school who can assist principals, teachers, staff, whoever it may be, with research, books, computer usage. There's all kinds of things. But I would think most importantly, because it's a spot where students can go to learn those skills. Every teacher isn't equipped to learn those skills, especially in a high school and middle school setting. So with that, that's the answer that I would give you. And even as a librarian 10 years ago, I was teaching more than just how to check out a book. And all students learn differently, and many students need a book. That's why we still have paper newspapers. People like them.
Other questions? Okay. What's the pleasure of the committee?
I move to amend and do pass.
I have a motion from Senator Donate to amend and do pass. Have a
Senator
second?
Lang will second it.
Second from Senator Lang. Any further discussion? Yes, Senator Donate.
Yeah, I just want to mention really quickly, I think the senators that brought this provision forward, I think that sometimes we lose the sight of how important school libraries can be to us. I think back to my childhood, and when we were in our classrooms in elementary school, they would pass around this pamphlet provided by Scholastic, and you would be able to purchase books. And I remember saving the dollar bill that I would find in the laundry so that I could afford the dollar book deal that we had in these Scholastic books. And my parents couldn't always afford a printer in our house, so I would always have to go to the school library. So libraries are helpful for a lot of people, so I'm supportive of this.
Thank you. Senator Hammond.
Thank you, Mr. Chair. I, for one, have not forgotten how important libraries are. I think they're great, and we've had them at every school that I've tried to be a part of. I think what we're worried about here is that having language prescribing certain areas in which the library needs to be in, or prescribing too many rigid details when you're talking about schools of choice, or you're talking about different kind of schools trying to get through things. That just kind of inhibits the ability of administrators to make decisions on how to still deliver the goods, but do it in a different way. And that's my concern. I think I had the same concern 2 years ago. I mean, you look at something like the UNLV Medical School. They even recognize that the need for a huge library isn't there anymore, because many of their students are, they're doing it some other place. They have access, and that's what matters. So it's just the flexibility that concerned me, and that's why I'm still having a hard time with this one. Thank you.
Thank you. On the motion, I will. I know the value of librarians, and in this committee, we're talking about the policy, and I firmly feel that we need to have, the librarians. They're trained to do. They're not just in a room full of books. They're trained to teach, and they're a resource for teachers. And in that respect, I support that. And I'm sure finance will look at the issues of money. But with the new funding centered pupil plan, funding plan, somebody mentioned earlier that we took away the money for Read by 3, but that's not true. The money for Read by 3 is there, and it's still in statute, and schools will be able to do it. And it just happens to be inside the funding formula. And so these libraries and things, as we move forward, they're going to be able to do that within their budget. So I support the bill, and we'll be voting for it. Any other further discussion?
Senator, if I could just add one other thing, just as a side note, you know, every major university, every community college, every institution of higher ed has a library and a research center, and there's a reason. And I think the important piece is that we educate kids and we raise them with those skills so that when they get into higher institutions of education, they have those skills ready with them. So I appreciate the thought, I appreciate the questions, and I urge your support. Thank you very much.
Okay, so any other questions on the motion? Senator Hardy.
Thank you, Mr. Chair. Librarians now are a different breed. They actually go to school to be a librarian. One of the things that this bill is doing is perpetuating the feeling that it's only a teacher that can become a teacher librarian or a school librarian. And I think that's probably a fallacy there. I think if we were going to get librarians, we ought to get librarians that are librarians. Medical schools have medical librarians. They're not physicians, they're medical librarians. I think that's a challenge and a problem with this particular bill. Thank you.
And Senator Hardy, Marilyn Dondero Loop, for the record, I actually did go to school and had to have a master's degree in order to be a public school librarian in Clark County, Nevada. So everywhere in the state, it's not like that, but in Clark County, in order to be a librarian, you have to be a certificated teacher and have a librarian credential.
Okay, any further discussion? All right, let's go to the vote. If we could do a roll call vote.
Vice Chair Dondero Loop,
Yes?
Senator Hardy,
No.
Senator Hammond,
No.
Senator Lang,
Yes.
Senator Buck,
No.
Senator Dunyate,
Yes.
Chair Dennis.
Yes, motion passes 4-3. Okay, let's go to the next one, which is Senate Bill 172.
Thank you, Mr. Chair. Jen Sturm for the record. The next bill on work session is Senate Bill 172, which was presented by Senator Dennis and heard on March 8th. Senate Bill 172 removes the enrollment application process and prerequisite requirements for a student to participate in a dual credit course. The bill also removes provisions relating to cooperative agreements to offer dual credit courses and instead requires each school district and charter school to establish a dual credit program. Furthermore, the bill requires reporting of certain information relating to dual credit programs to the legislature and requires the Interim Legislative Committee on Education to study dual credit programs. Senator Buck proposed an amendment to include provisions regarding a uniform grading scale for dual credit and international baccalaureate courses, and requiring the scale to assign the same weight to such courses as those assigned to advanced placement courses in certain circumstances. Senator Dennis proposed an amendment, which is attached to this work session document, to make the following changes. The first would allow school districts and charter schools to partner with other school districts that have an existing dual credit program, and two, generally revises the reporting and data collection requirements. Mr. Chair.
Yes, questions on any of the
Mr.
motions?
Chair.
Yes, Senator Hardy.
So I'm on Nellis. I don't see Senator Buck's amendment, but obviously I would support it and even say maybe she would like to be, I don't know if she would or not, but maybe she'd like to be on your bill as a sponsor, understanding that I don't see the amendment, but I think it should be there. Thank you.
Thank you. I believe that the amendment was a verbal amendment when she was giving her testimony during the hearing. And I think that's where we got that from. It wasn't, she didn't submit it officially, but we had a discussion, and so I included that. And I gave her credit for that, for having done that. So that's why we don't have a physical piece of paper. And we can always add her as a sponsor anytime. We could do that from the floor, for that matter.
I think that would be wise. Thank
Yeah, because you could just, whoops, sorry, Chair Dennis. You could just take whatever was in the bill I had and put it in there. That'd be great. That would give students that are sitting in a college classroom credit, GPA credit for it, weighted the same.
Yeah, the weighting part is what we were talking about there, to make sure that they all weigh equally. Other questions? Okay, I will entertain a motion.
Move to amend, do pass.
Motion Senator Hardy to amend and do pass. We have a second.
From Senator Buck.
Second from Senator Buck. Any further discussion on the motion? Okay, let's take a roll call vote.
Vice Chair Dondero-Loop,
Yes.
Senator Hardy,
Yes.
Senator Hammond,
Yes.
Senator Lang,
Yes.
Senator Buck,
Yes.
Senator Dunyate,
Yes.
Chair Dennis.
Yes. Motion passes. Let's go to Senate Bill 210.
Thank you, Mr. Chair. Jen Sturm, Committee Policy Analyst. The next bill before you today is Senate Bill 210, which is sponsored by Senator Dondero-Loop and was heard on April 5th. The bill relates to the education of a child with an emotional disturbance. The bill requires a psychiatric hospital or residential mental health treatment facility to which such a child is admitted to develop a plan for continuing the child's education in consultation with certain stakeholders. The bill also outlines requirements for the development and compliance with the provisions of the bill. And there were a couple or a few amendments here proposed by Senator Dondero-Loop, and those are also attached to the work session document. The first would distinguish admittance processes between an acute psychiatric treatment center and a residential treatment center. Two, it would include relevant language in NRS Chapter 433B concerning child welfare and education to ensure there's jurisdiction over the provider to ensure compliance and uniformity. The proposed amendment would include relevant language in Chapter 388E of NRS concerning the educational rights of foster children to ensure that section of NRS complies with the new provisions established in this bill. The next proposed amendment would clarify that a meeting will be convened prior to the admission of a student to a residential treatment center and further clarify the different processes depending upon whether a student is identified as having special education needs or not. And finally, it would allow the Department of Education to develop regulations related to the discharge of students from such facilities and their re-entry to school. Mr. Chair.
Thank you. So 210. Senator Dondero-Loop, any comments?
Thank you, Chair. I have Ms. Bailey Bordelin on the line. If we have questions, I would just only say that these are some of our very most vulnerable students that we are trying to make sure that their schooling is not disrupted. So if there are questions, Ms. Bordelin, and I believe Ms. Reed from the Nevada Department of Education is also on the line.
Do we have any questions from anyone? I'm not hearing any. I will
Chair, amended do pass.
have a motion from Senator Buck to amend and do pass.
Second.
Second from, was that Senator Hardy?
Yep.
Second from Senator Hardy. Further discussion on the motion? All right, let's do the roll call vote.
Vice Chair Don Daraloop,
Yes.
Senator Hardy,
Yes.
Senator Hammond,
Yes.
Senator Lang,
Yes.
Senator Buck,
Yes.
Senator Dunyate,
Yes.
Chair Dennis.
Yes, motion passes. Let's go to Senate Bill 287.
You, Mr. Chair, Jen Sturm, Committee Policy Analyst. The next bill today is Senate Bill 287, which is sponsored by Senator Harris and heard on March 31st. Senate Bill 287 relates to the land grant status of the University of Nevada. The measure designates certain entities as the state land grant institutions and the Board of Regents as the governing authority of the University of Nevada. Further, the bill requires the Chancellor to administer the assets of the state land grant institutions. And finally, the bill prescribes the method of accounting for assets and distributing profits generated by the institutions. We do have a couple amendments proposed for this bill as well. The first set proposed by Senator Harris would be to delete the language of the bill as originally drafted and replace it with the following. One, designate the DRI, UNLV, and UNR as the state land grant institutions. Require the Chancellor of NSHE to develop a plan to manage the assets and resources of the state land grant institutions and require the Board of Regents to approve such a plan. 3, require the plan to be submitted to the Legislative Council Bureau and the Governor. And 4, include an effective date for the bill. The next set of amendments proposed came to us from the Nevada Association of Counties, which proposed similar concepts as those I just referenced, but also contains provisions to, 1, include certain stakeholders on certain committees the Chancellor may establish in order to develop the plan to manage the assets and resources held by or afforded to state land grant institutions. And 2, include the requirement that certain funding allocated to the agricultural extension and experimentation programs continue to be appropriated to and expended through those programs established prior to July 1st, 2021. Mr. Chair.
Thank you. Is Senator Harris on the line? I know she had to go to committee. Oh, there you are.
I jumped back over.
Okay. You have any comments?
No, I'd be happy to answer any questions that the committee may have prior to accepting a motion if you'd like.
Thank you. Senator Hammond.
Thank you very much, Mr. Chair. Yeah, I do have a few questions. In 2017, I was a co-sponsor with then Assemblywoman Olivia Diaz, looking at this very same issue. My major concern when I got involved was the fact that there was money left on the table in different jurisdictions, especially down in the South in Clark County, where we generate money down there. The money has to be spent down there, and nothing was happening. Since 2017, a lot of effort has been expended to try and get the right personnel in the right places, and then develop these programs. It's been working wonderfully. I haven't had a chance to digest the new language, the technical language that we just heard. If you could break it down for me, what I'm looking for is this. I think I heard at the very end, basically the agreement you have now and what's going to be in the language is that UNR will continue to basically work the cooperative extension. They'll receive the funding from the federal government, the $2.something million. Make sure the programs that have been established continue to go, because I do not want to see an interruption in that. That's one of the things I don't want to see is an interruption if the language of this bill does that, I'd be a no. But I want to make sure that that doesn't happen. And then I'd also like to know and get a little bit more clarity, maybe from you or somebody else. The assertions that were made during the hearing is that if DRI and UNLV are given land grant status, that they would actually be able to receive more money. More money would be coming into the state. On the other side, the assertion was no, the money remains the same, that it's stagnant, but it would be split up in three. It split up into three different pots, essentially going to UNLV, UNR, and DRI. I want to know, is there, what can somebody explain to me what increase we're talking about? Maybe there's not an increase in the amount of money coming from the land grant, for cooperative extension. Maybe that doesn't increase, but as long as it all goes to one entity and they're working that and still keeping the programs, and yet more money is coming in from something else, I'd be okay with that. Can you, I'm sorry, I hope I'm very clear on where I'm at.
No, that's perfectly fine. Thank you for the question, Senator Hammond, to you through you, Chair Dennis. I'm going to try and take an initial crack at that, and then I'll invite Mr. Hardy or Ms. Schaefer to supplement my answer as necessary. As to your first part about UNR operating the co-extensions and trying to avoid a disruption in that program, yes, it is my understanding you're correct. The amendment you see before you is designed to do exactly that. When it comes to your question about the single pot of money or different grants available and whether you have to split it up, I'll have to defer to the experts, but I can tell you right now, Senator, that there are grants that exist that UNLV currently doesn't apply for in order to receive, because they are only grants that land grant institutions can compete for. And so I see this as an opportunity to allow the two clear land grant institutions, UNLV and DRI, to make sure they're eligible for those grants and to put themselves forward for funding that they feel they currently don't qualify for. I'll turn it over to you, Mr. Hardy or Ms. Schaefer, for further explanation.
Thank you, Chair. Chair, Senator Harris really hit the nail on the head. And let me go into a little more detail, because I think the document, the amendment document we should be looking at is the NACO document. The NACO document represents the agreement that Senator Hammond referenced in his comments. So the intent of this, I agree with Senator Hammond in terms of pre-2017, Southern Nevada didn't have much of a voice or enough of a voice in how those dollars in Southern Nevada were spent. And so I know that to give credit, I know I'm not supposed to mention individuals, but Commissioner Marilyn Kirkpatrick has done a marvelous job. Maureen Schaefer, who's on the call, is also a member of that board, has done a marvelous job in making sure that Southern Nevada has gotten their fair share with regard to the cooperative extension. That's the reason we were 100% comfortable in this legislation adopting the NACO amendment at NACO's request to hold harmless all matters related to the cooperative extension and direct the chancellor to develop cooperative agreements between the two universities on that. With regard, and Section 3 of the amendment speaks to the fact that those dollars would be held harmless. Those dollars will continue to flow to the current source until such time as the two institutions, through the work of the chancellor, agrees on a different method. So the answer to your question is, Senator Hammond, that all those things are accounted for. I would also point out that the chancellor has seen and spoken in favor of the NACO amendment. With regard to your final question, I just want to expand on what Senator Harris said a little bit, because that's the crux of this for us. We have taken every effort to remove the cooperative extension language, to allow that to function as it's currently functioning until the universities agree that it should be done in a different way. And that will be done through the chancellor, which is appropriate. The reason for this legislation, and the reason for what I'm going to call a clarification in land grant status, because that's all this is. The chancellor, if you may recall at the hearing, that General Counsel for NSHE opined that the land-grant universities in Nevada currently are UNLV, UNR, and DRI. So this is a clarification. But the reason for that clarification is that there's confusion on the national level because of history, because of culture, as to whether UNLV and DRI are both land-grant institutions. Why is that important? As Senator Harris said, there are some land-grant grants that we're not able to apply for. But in most cases, and this is the most important thing, being a land-grant institute gives you a step up. It gives you the ability to, this is not entirely accurate, but for lack of a better term, and maybe it is, I don't know, move to the head of the line. And more importantly, it also gives us the opportunity to receive federal grants that do not require matching state funds. That's the disadvantage that UNLV is currently under. That is the disadvantage. That is a competitive disadvantage we have. We are not looking for that pot of money, and that's where the confusion is. The pot of money is the just over $2 million that currently flows to the system. Our amendment, we're not touching that. We don't have anything. That's fine. That's not the big issue for us. Is our ability to access funds as a land grant university in Southern Nevada, and the big advantage of that is that many of these we don't have to do. We don't have to have matching state funds for. This is a significant issue for Southern Nevada. And I know I ranted, Mr. Chair, and I apologize for that, but I do appreciate the opportunity to make that clarification. And thank you, Senator Harris, as well.
Other questions? Yep, Senator Dunn-Loop.
I appreciate that discussion and appreciate the amendments that have been proposed, especially the NACO one that is listed on our book. But if there are no more questions, I would move to amend and do pass if there are no more questions, Chair.
Let me see if there's any more questions. Any more questions? Senator Hardy.
Thank you, Mr. Chair. So it was kind of interesting during the testimony that UNLV, UNR, DRI, or at least UNLV, UNR are land grant institutions, as the former Senator Hardy said. UNR seems to think that there's not going to be more money. If we do have the chancellor in charge of the administration of the money, and the Board of Regents is in charge of the plan of the administration of the money, then obviously where the population growth is going to be in the UNLV basket, I'll call it. And so then you start looking at other evidence, and you look at the fiscal note on this bill, for instance, and it actually takes money from UNR. And unless I'm meeting it wrong, after review of the proposed bill, University of Nevada, Reno has determined that there will be a fiscal impact to UNR, College of Agriculture, et cetera, et cetera. So I think we're ahead of our skis. And I don't think we've fully vetted what the impact is going to be. And the shift of demonstrated representation is going to come from this area. And I worry that the small person in the north that's already done a good job and continues to do a good job with the extension program will not be able to keep up with what they're supposed to be doing. So I will be a definite no, with the right to change my mind. And I've been called by pretty much everybody from UNLV so far. So I look forward to those calls to continue. Thank you.
All right. Any other questions?
May I just address that really briefly? I beg your pardon. I just want to point out
yes, go ahead.
Thank you, Chair. I just want to point out that the fiscal note that Senator Hardy is referring to was on the original bill. And in fact, again, I need to make the distinction. You've got a pot of money that comes to Nevada just by virtue of the fact that we have a land grant. That currently goes to UNR to be distributed through the cooperative extension. under the original bill, that would have been divided into 3 parts, which is where the fiscal note comes from. Under the amended bill, that money continues to flow to where it's currently being spent, which is UNR for the cooperative extension. So that's where that fiscal note comes. And so the answer to Senator Hardy's question is both parties are right. There is a pot of money that would, under the original bill, be divided in 3 parts and take away from UNR. That is amended out. The bigger concern, the real money, if you will, is on the other side. And that pot becomes immeasurably larger for UNLV and DRI. UNR already has access to it, but this opens it up to where UNLV and DRI can also pursue those grants without federal matches, or excuse me, without other limitations that occur for non-grant land grant universities. So thank you, Mr. Chair, and I just wanted to make sure that was clear on the record.
Thank you. Senator Lang. So Senator Lang, did you have a question?
I'm good.
Okay. Anybody else have a question? All right, then I'm going to take a motion from Senator Dondero-Loop.
Second.
I think Senator Hardy did have a question.
Oh, sorry. I missed that. Senator Hardy, do you have a question?
Yes, obviously, there's a statement of fact that UNR and UNLV are land grant institutions. I don't see anybody contesting that. So when we say we're going to make them a land grant institution, they already are. So I'm open to that education, I'll call it, if that has been a false statement all along.
Mr. Chairman, thank you, Warren Hardy, for the record. And I should indicate I'm representing the Council for a Better Nevada today. I think I neglected to do that. So Senator Hardy, I believe, and she believes, the last Attorney General opinion on this from 1969 believes that UNLV, UNR, and DRI are the land grant institutions for Nevada. This is a discussion I had with my friend and mentor, Senator Bill Raggio, many, many years ago. There is a narrative that comes out of UNR that they are the only land grant institution in the state. That narrative, and as far as I know, they're the only ones that believe that. And so there's a narrative that comes out of UNR that has pervaded the country, if you will, that they are the only land grant, and it has acted to cause confusion with the federal government. It has added to cause confusion with granting institutions across the country, which has been a barrier to UNLV. The statute currently, as it exists today, is somewhat confusing on the matter, which is what we're trying to clarify today, that these are the institutions. I hope that answers your question, Senator, but we feel like we need clarification in the statute once and for all. Thank you.
Senator Hammond.
Thank you, Mr. Chair. And I apologize. It's just something that keeps coming back to me, because in 2017, this also happened, and there was discussion. And again, I think it happened in the hearing we had the other day, where UNLV did state, I believe, that they have received grant money and an application in which they were designated a land grant college. Has it happened that you have applied for grant money as a land grant and been denied because the grantee said that you were not a land grant college?
Thank you, Mr. Chairman. Warren Hardy for the record. I don't have specific examples of that. I know there are instances, and there have been instances in the past, where we have, on a case-by-case basis, had the chancellor indicate that yes, UNLV is a land grant status for purpose of this grant. And so that has happened in the past. Often we don't pursue grants because of the state matching fund requirement, and so we're not able to access that without the state matching funds. I'm not an expert on that. I've given you about the extent of my knowledge, but yes, grants have been given, and prior chancellors have been willing to say on a case-by-case basis, for purposes of this grant, UNLV is a land grant state. That, Senator, is inappropriate. UNLV is part of the Nevada system of higher education, and it should be clear in the law that UNLV has the right and the ability to pursue all of these grants, just like UNR, just like DRI. There is nothing in this legislation that harms UNR in any way, shape, or form once you remove the first pot of money, which we have done in the amendment.
Ms. Schaefer, were you going to add something to that? I thought I saw you move.
Thank you.
Ms. Schaefer, go ahead.
Yes, thank you. I would only add that as a former employee of UNLV, when I was helping to found the medical school, it was clearly dictated to us and many of our colleagues throughout the campus that we were not a land grant. And if we or any of our colleagues at any of the other schools throughout campus were seeking to pursue any applications through the federal government, we needed to seek permission through the chancellor's office. And so our former head of research at UNLV expressly said to us on many occasions that we were not a land grant institution through messages from the chancellor at the time. So I only say that as information as a former employee at UNLV from just direct information. While this may be on statute, and I respect Senator Hardy's clear understanding, this was and continues to be urban legend passed through down to the campuses and practiced on a daily basis. And this clarification, this reaffirmation that UNLV and DRI are in fact land grant institutions is critical, it's invaluable, and it will translate into tens of millions of dollars back to these campuses and into the hands of faculty. And it's extraordinarily important that we reaffirm and we clarify this status because it's not happening. It's not happening to this day.
Thank you. Mr. Killian, can you weigh in on this issue?
Thank you, Mr. Chair. Asher Killian, Committee Counsel. So our office's position is consistent with that expressed by Mr. Reynolds, the Chief General Counsel for INCHE at our previous meeting, as well as the Attorney General in Attorney General's Opinion 1969-556. Article 11, Section 4 of the Nevada Constitution empowers the legislature to establish a single state university. And Article 11, Section 8 reserves land grant funds for the support of that state university. The legislature has chosen to establish that single state university as the University of Nevada, and the University of Nevada happens to have campuses at multiple locations, including Reno and Las Vegas. So consistent with INCHE's opinion and with the Attorney General's opinion, it's your legal division's opinion that there is a single University of Nevada with campuses at multiple locations. And that single University of Nevada is the state university, which is a land grant institution. None of those campuses hold land grant status independent from the University of Nevada, but rather the University of Nevada as a whole holds that land grant status, and that extends to all of its campuses, including the campuses at Reno and Las Vegas.
Thank you.
Chair Dennis,
Yeah, Senator Don Durloop.
when you're ready for a motion, I'll restate it, but I just need to put on the record that the whole purpose of this bill is to state that UNLV is a land grant institution. So if someone, whoever we are on this committee, does not have an issue with that, then I would think you would be voting yes, because you'd just be confirming that UNLV is a land grant institution. And I can tell you 100%, because I asked the question, UNLV has not received grants solely because they were designated land grant. So, you know, if UNLV is a land grant institution, then, or is not a land grant institution, then why are we having this discussion? So All we're saying is that the institutions involved are all land grant institutions for the purpose of applying for grants.
Senator Buck.
Thank you, Chair Dennis. So I just want to confirm that this language guarantees that UNR continues to run the extension, but that UNLV is a land grant institution also.
Mr. Chairman, would you like me to take that?
Yes, please answer.
Thank you, Warren Hardy, again for your record. That is correct, Senator Buck. As drafted, this clarifies the NRS statute to match the constitutional opinion of your legal counsel, of NCHI, and of the Attorney General in 1969, that those are the three land grants. It holds harmless. It makes no changes whatsoever relative to the current first pot of money, the $2 million that flows in, and to the way that the cooperative extension is operated. It does assign the chancellor to try to do a study to look and make sure that's fair and equitable for all institutions, but it gives her the direction to do that, the current chancellor the direction to do that. It is not prescribed in the statute.
Okay, thank you.
Mr. Chair.
Is that Dr. Hardy? Yeah, Senator Hardy, and then we'll go to Senator Lang.
I appreciate the clarity and the admission that UNR, UNLV are one university system. The chancellor is over that system. The regents are over that system. So as I look at this particular bill with that admission that happened originally in the hearing, that we're okay, and quite frankly, we don't need this bill because it's already a fact. And it didn't take the Attorney General in 1969 to say it's a fact, because it has been a fact. Now, knowing that it's a fact and knowing that the chancellor is the chancellor over the whole system, likewise the regents, I feel it easy to vote for something that has already been established as a fact. Thank you.
Thank you, Senator Lang.
Yeah, thank you, Chair Dennis. So there's a cooperative extension in Las Vegas too. It's on Windmill and the 215. I'm just wondering, where are they going to get funding from? Because we talk about the one up north, but there's one in the south as well.
And to that, if that's Senator Dennis, and then again, please, Mr. Hardy, if I miss anything, jump in. Thank you for the question, Senator Lang, to you through Chair Dennis. With this amendment, the funding sources will not change. They will continue to be funded as they are with UNLV, UNR still running the cooperative extension program at both locations.
Other questions, comments? Not seeing any or hearing any. Senator Dunderloop.
Thank you very much. I would move to amend and do pass Senate Bill 287.
I'll second that motion.
Okay. Have a motion from Senator Dunderloop, second from Senator Lang. Further discussion on the motion. Okay, let's do a roll call vote.
Senator Dennis, if I could just say one thing before we vote.
Yes, go ahead.
So, Assemblywoman Bilberry Axelrod sent me a note this morning, and because she knew that we'd be voting on this, and she said that her dad has been working on this for years. So this isn't something that's new. It's something that I think people in the South have been working to get happen for a really long time. And so I'm really happy that it's going to finally be in law. Thank you.
Thank you. Okay, let's go to the vote. Roll call vote.
Vice Chair Dunderloop,
Yes.
Senator Hardy,
I will vote for something that's already been in the law, including the Constitution. Yes.
Senator Hammond?
I'll be a yes with my right to reserve. Change my mind if I looked at the information later on and
Senator Lang?
Yes.
Senator Buck?
Yes.
Senator Dunyate?
Yes.
Chair Dennis?
Yes. Motion passes. All right. We're going to go to Senate Bill 347.
Thank you, Mr. Chair. Jen Sturm, Committee Policy Analyst. The next bill is Senate Bill 347, which is sponsored by Senator Scheibel and heard on April 2nd. The bill relates to sexual misconduct at higher education institutions. The measure creates the Task Force on Sexual Misconduct at Institutions of Higher Education and prescribes the membership and duties of the task force. Further, SB 347 authorizes the Board of Regents to require an institution to examine and address certain matters related to sexual misconduct as outlined there on the work session document. The bill allows the Board of Regents to impose a fine against an institution that does not comply with the requirements. Finally, SB 347 requires the Board of Regents to compile reports from institutions and forward them to the Department of Health and Human Services and to the legislature. And then we did receive proposed amendments from Senator Scheibel, which are attached. And I summarized a lot of the main points here, and I'll go over those, but I understand that Senator Scheibel may be on to answer questions as well. So the first proposed amendment defines several items as identified there in number 1. Number 2, it revises the membership of the task force. 3, provides for the development of a climate survey. 4, provides for the Board of Regents to conduct a sexual misconduct survey biennially at each institution. 5, clarifies the investigative, disciplinary, and non-disciplinary processes as specified in the bill as written. 6, clarifies how the sexual misconduct policy may be provided and the contents of such a policy. Number 8, provides for the development and adoption of a memorandum of understanding with regard to sexual misconduct incidents. Skipping down to 10, the proposed amendment provides for and defines the duties of a confidential resource advisor. 11, further provides for the response to reports of an alleged incident. Number 12, authorizes the Board of Regents to provide investigative, disciplinary, and non-disciplinary training to certain employees and allows the board to require institutions to cover certain topics in training. Number 14, provides for the annual reporting of sexual misconduct incidents. 15, provides for the institutional disciplinary process and related reporting, as well as an institution's response processes to incidents, including hearings and investigations. Includes a waiver from requirements of school-sponsored programs and activities, including scholarships for those who have experienced sexual misconduct. And finally, number 17, ensures compliance with federal law. Mr. Chair.
Thank you. All right, Senator Scheibel. I think she's on.
This is Lily James for the record. I am the co-executive director of the Our Voice Coalition. Senator Scheibel, unfortunately, is caught up in Judiciary Committee.
Oh, yes.
So is not able to join us, but myself and Sage Carson here, manager at Know Your Nine, are here to answer any questions from the committee today.
Okay, so do you want to talk a little bit about, because this amendment came after we had the hearing, so want to talk a little bit about that?
Absolutely. Thank you so much, Chair Dennis. This is Lily James for the record. So this is we submitted an amendment prior to our committee hearing last week. And then this is a sort of slightly revised amendment to that. We worked closely with some representatives of NSHE to get to a place where we all felt really confident in this bill. And so this sort of second version of that amendment is one where we've worked really hard to get to a place where everybody feels really good. And that's sort of what accounts for the differences in the two. But it is
Mr. Chair.
Yes.
Joe Hardy.
Senator Hardy.
Where is the amendment?
I believe the amendment is out on in the actually, Ms. Sturm, is the amendment out? The amendment's out.
I have it.
I think if you, Joe, Senator Hardy, if you just go to today's, you just go to today's meeting, and the whole meeting, it's on blue. It just says Senate Education Committee. If you click on that, then a bunch of stuff comes up, and one of the things that comes up is it says that, I think, exhibit, and then you hit that, and it'll say work document or work session document. And then the work session document, it has all of the different Senate bills, and then the Senate bill. You can click on this Senate bill, and all the amendments come up.
So the amendment is a 14-page amendment, starts with section 8.
Hold on.
Or is that a different amendment?
I don't think so, because the one I have, it starts with section 2, I believe. It has a bunch of notes before that, and then it starts in with.
So let me. It says BDR 34-237 SB 347 conceptual amendment at the top. Starts with section 1, and it's got.
I have the same thing that it starts with section 8.
Okay, I don't know. We could.
And that's on Nellis.
Mr. Chair.
Okay, hold on. We got too many people talking here. We've got, so Senator Hardy, I don't know if it's just not printing out for you, but it's out on Nellis with this bill. We could maybe try to get somebody to staff to run one down to you.
So.
Anybody else having issues with pulling up the amendment?
So I go to Melanie Scheibel's conceptual amendment, and mine goes BDR 34-237, and then it starts blue, green, red, and then it starts section 8.
Okay, let me put Ms. Sturm on. She knows what you're looking at. So hold on, let Ms. Sturm.
Thank you, Mr. Chair. Jen Sturm. The proposed amendment, I believe you're looking at, Senator Hardy, maybe the one that was originally submitted for the bill hearing. Since then, there was an amendment submitted replacing that one, which is attached to the work session document. And it's the amendment, proposed amendment itself is, I believe, 24 pages. Not the 14.
So when I go to the work session document and click on SB 347, and then I go to exhibits, because there is no amendment, I click on exhibits and I get down to 347 conceptual amendment, Senator Melanie Scheibel. And I get back to the same place I was before, section 8. Can somebody email me this mystery conceptual amendment?
You should have it. Somebody just emailed it to you. So if you look, I know Senator Donate said he.
It is also in our work session document.
That's my point. It's not.
Okay, so
apologies. It's in ours, so apologies. But somebody just emailed you the link.
Senator Hardy, if you can't bring it up, I'll bring it down.
Okay, I don't know who's speaking because everybody's speaking all at once. If everybody will just let me do the speaking, and then the Senator Hardy,
okay,
somebody has sent you a link. Do you have that?
Yeah, I got it from Asher, Senate Bill 347. And I'm looking for the amendment now on Asher's email.
While you're doing that, Mr. Killian, did you send him the full document? Is that what you sent?
I got it.
Mr. Chair, yes, Asher Killian Committee Council. I sent him the full work session document, including the amendment.
Great.
I got it from Asher. Thank you, Asher.
All right. And everybody else has it, or they would have said something by now. All right. So I don't know where we were at. I believe Ms. James, I think you were, yep, go ahead.
Or Lily James for the record. So I think what I was saying is that this sort of second version of the amendment that we had last week is very similar to that one, just some sort of tweaks and changes that came from some great discussions with some folks at NSHE. Again, just getting to a place that we all felt really confident with the bill. And Sage and I are here to answer any questions from the committee.
Okay, so questions. Yes, Senator Hardy. Senator Hardy, we can't hear you if you're speaking.
So we heard in testimony 40% of people had been sexually victims of this sexual misconduct. And now we're going to give a percentage of tuition to all of these people. Is that true, or is that changed in your amendment?
Ms. James, or is it Ms. Carson?
Sorry, Sage Carson for the record. I'm happy to answer this question. So this is not to provide additional money to those students or to provide them tuition. Instead, this is to recognize that folks that experience sexual violence in education experience large educational impacts because of that violence. For example, we surveyed about 110 student survivors and found that all of them experienced negative impacts on their GPA. And 1/3 of student survivors were asked to either take time out of school completely or to go down to partial or half time. A lot of student survivors who experience these academic impacts and penalties lose access to scholarships and educational opportunities because of the negative impact that sexual violence has on their education. This is not to provide them with tuition entirely. This is to make sure that if a student has experienced sexual violence and their GPA drops because of it, or if they need to go down to part-time so that they can focus on their educational success, that they don't lose access to educational opportunities because of that violence. So it's really more to ensure that survivors who have a negative impact on their education can continue to access the benefits of education following the violence.
So, Mr. Chair, we're mixing words. Are you talking about sexual misconduct or sexual violence now?
Ms. Carson?
Carson for the record. Sexual misconduct and sexual violence, I'm using hand in hand as terms, but I'm happy to continue using sexual misconduct if that is what you would like.
I mean, they're different.
Apologies. Sexual misconduct is a way of describing sexual
Carson,
violence.
whenever you respond, you need to always say your name so that the record is clear who's saying what.
Apologies, thank you. Sage Carson for the record. Sexual misconduct is typically a way that institutions respond to or describe sexual violence. Sexual misconduct includes sexual harassment, sexual assault, stalking, intimate partner violence, and domestic violence. And we use the term sexual violence to include all of those pieces as well, but moving forward, I will be ensured to use sexual misconduct for the hearing.
Well, let me say it this way. Is sexual violence a crime and sexual misconduct is a lesser crime?
Lily,
I mean, when I think of sexual violence, I think of violence, and sexual misconduct is a broader umbrella from what I've understood from what you've said. And sexual violence, you're going to have to say if sexual misconduct is a crime punishable like rape, then we need to know that.
Lily James for the record. Thank you so much, Senator Hardy. So in the bill, as defined, sexual misconduct is the umbrella term that encompasses a wide range of other sexual violence, sexual assault, sexual harassment type of behaviors. So in the bill, we do refer to sexual misconduct, but colloquially, we do sort of say sexual misconduct or sexual violence. And I will, to what you're saying, to what you're speaking to, this bill does not really speak to nor address, any sort of criminalizing of these pieces. It's more flipping it from, the perpetrators and anybody who's doing any of the violence to instead focusing on how can we support survivors of these incidents who, as Sage spoke to previously, often experience long-term and severe impacts on their education and then, continual life opportunities. And so we're focused primarily on those supportive measures for survivors as well as then prevention. So, we in the bill do not address anything as it relates to, criminalizing sexual misconduct or sexual violence, but using the terminology, we use the terminology sexual misconduct to refer to all of the behaviors that we're working, actively to prevent and then support survivors of.
So if I may, if we had 10 rapes and 8 rapes and 6 rapes successively in UNLV, let's put it that way, age group, and we had 40% of people who've had sexual misconduct, I do not want Nevada to become tarred with the reputation that we have had more than other people. At the same time, if we don't do prevention, which is where I think we need to pay attention to in grade school and middle school and high school, if we don't do prevention, we're going to get more what I would call sexual misconduct, but I would not say sexual violence. And so, yes, there's violence. Yes, those are arrested, those are prosecuted, and we can track those. But trying to track and say that we have this many sexual misconduct and lump that together, I think that is a disservice to what we're trying to do in the state of Nevada.
Senator Lily James, for the record. Senator Hardy, thank you so much for speaking to this. By all means, we're not trying to lump these behaviors in together. It's more of making sure that this is an inclusive definition so that survivors who have experienced some sort of violence, whether it's domestic violence or sexual harassment, which do look different and come in different forms, we are looking to just ensure that no student who has experienced this type of behavior feels like they are not able to access support or access accommodations or receive the sort of supports post-incident, that maybe what happened to them doesn't sort of fall under the purview of some other sort of definition. So by making it as broad as possible, we're really ensuring that, across the board, anybody who has experienced this violence or misconduct, or harassment is able to receive the sort of supports that they deserve and need. So it's sort of, I would again say it's really about flipping this to making sure it's as inclusive of different survivors' experiences so that there's no one who is, left out and therefore not able to, and is hurting and is experiencing, ramifications or deteriorating GPA or other sort of educational experiences because of this. But because what happened to them doesn't sort of, qualify or, fall under the definition, they're not able then to, receive supports. So it's really just making sure that across the board, we are able to support everyone. That was the intention by making it a broad definition. But again, I will say to your excellent point, we're not interested in, lumping them in together or making them synonymous by any means. That is not the intention of the bill. It's more just to be inclusive of, as much behavior and, as inclusive as many survivors who've experienced different forms of, misconduct. Thank you.
I appreciate your clarification. I think you need to rewrite some of this so that it makes it clear to other people. Thank you. Thank you, Mr. Chair.
Thank you. Other questions? Yeah, Senator Hammond.
I don't know if I have so much as a question as just I appreciate my colleagues' line of questioning, and it's sort of the same thing I have. I know that there's a problem on campuses across the United States. And I think that it's important to get after that particular issue. But I think with the language being as broad as you have it, I think that you're inviting a host of other problems. I think most of which is freedom of speech, because I think once you send out the survey, the climate survey, and then you have these groups that are part of this council being talking about what's acceptable, what's not. I think what you're doing then is sort of a chilling effect on who's going to be able to say what in certain areas, crowds, at the student union, even a conversation that's overheard. Maybe somebody feels that they may have been harassed in some way. Now all of a sudden you have an incidence where you're reporting more and more, as Senator Hardy had mentioned. Now all of a sudden it looks like our campuses are rife with all kinds of misconduct, and that's kind of the worry that I have. It's really just too broad of language for me when you're defining a lot of stuff. And I think it was in either section 2 or 3 that was housed in the definitions were housed in. So that's I guess just a statement. But if you want to address it, feel free. But that's kind of where I have a hard time with the bill, because I just think it's asking for too much with so many moving parts and not enough time to work on it.
Lily James for the record. Thank you so much, Senator Hammond, for that follow-up question. I totally hear what you're saying. Again, that's not, really what the scope of this bill is. I will say right now, there just is really no adequate way to know what is happening on our campus. There's no widespread, reliable, consistent amount of data that we have on this issue. But, some of what we do know is that right now, only 5% of survivors on college campuses are making any sort of formal report. And that means, that their cases are accounted for by their school, are in official, Clery Act logs, or something of that sort. So that means that only 5% of survivors are, able to, get any sort of accommodations or support that is, contingent on reporting usually. And what we know, from other data is that close to 2.3 million current college students across the country, have experienced this kind of violence. But then from there, again, we only see that 5% are reporting. So I would actually say that it's not about an issue of reporting more so, and that, when we broaden the scope of who's able to come forward and, gather data on it, it's not that, we're going to be uncovering something that we didn't know exists, because we know it exists and we know it's happening. There just is no reliable way to actually give survivors a way to have their stories accounted for, that then from that data, schools are able to better know how to prevent it, right? So from that collection of data, they can say, okay, here are some sticky areas, here are areas that are particularly dangerous for students, where do we need to be preventing more? Where do we need to be funneling in resources? So it's more about collecting this adequate data that then goes into that prevention piece that you speak to, that to us is exactly what we're interested in doing ultimately. We know that this is just a first step. We need to be focused more on prevention, but we can't do that until we have this sort of data. So again, I would say that it's not about, racking up the numbers and racking up the reports by any means. It's making sure that it's not just being swept under the rug, that there is, really a official record of what's happening so that we better know how to prevent, and it's not just being silenced.
Thank you, Ms. James. I appreciate that. But again, it goes back to that little piece that you said, that violence, you kept using the word violence, 2.3 million cases of violence. During your hearing, you actually mentioned that you actually gave us a number, 12,000 12,000 cases. And I wanted to make sure, could you go through that one, just real brief? I know that there's other members who have questions. This will be the last thing I ask you, because you said 12,000. Was that 12,000 cases of violence as defined by Senator Hardy? We're talking about violence, or harassment and violence and all the other ones included in that? And is that in one university or throughout the state of Nevada? And over how many years? Is that 1 year or several years?
Lily James for the record. Thank you, Senator Hammond. I appreciate it. And I appreciate your careful note taking on our previous testimony. That's really awesome. So when I was giving testimony last week, and when my fellow colleague Geneva, who's a student at UNR, was giving testimony with me, we were citing the Nevada students, the current Nevada students, which is something like 12,000 from sort of estimates that we know. That 2.3 million is a national statistic, and that 2.3 million national statistic, and then that 12,000 are current students. So anybody who is currently enrolled. I myself am a senior in college, so that's my peers and my other fellow current college students. So just thinking about the scope of that and the real sort of sense of that is current, and that does not account for any sort of former generations by any means. And to speak to your question, that does take into account some sort of a broader definition of sexual violence, which again I will say is one of the reasons that we need to get more specific data, so that we do have a better sense of what's actually happening and what is harassment versus stalking versus violence versus domestic violence, right? And I think what you're pointing to is really great, and it's really what we're aiming to get to with this bill, is more specificity, more knowledge of what's happening on these college campuses that right now we just don't have a good sense of this, other than these sort of estimates from any sort of data collection that's currently been happening. Thank you.
Okay, Senator Don.
Thank you very much, Chair Dennis. As a mother of 3 daughters and 3 granddaughters, and in our family we've got lots of girls, I guess I just struggle with the fact that we're worried more about what it might look like than protecting our daughters or our sisters or whoever they may be in our loved life of family or friends. So a comment, and I believe that if broadcasting can pull up, there's somebody with the last 3 numbers of 269 that is willing to jump in here from NCHE. But I believe that we need to be cognizant of the data of where it's at, so that we can fix and help and assist to what's going on.
Okay, thank you. We'll try to pack somebody in case you have any questions for NCHE. I think we have somebody from NCHE that we could ask questions of. While we're doing that, Senator Buck.
Thank you so much, Chair Dennis. So I know Assemblywoman Torres has been working closely with NCHE this past year on issues just what you're talking about. And so have you actually spoke to campus college leaders, to NCHE leaders? Because it's one thing to do it with them than to do it to them, to have buy-in. So will NCHE be on board with your bill?
Lily James for the record. Senator Buck, thank you so much. And that's a really important question. I appreciate you bringing it up. The answer is yes. So we had several meetings recently with NCHE folks to really solidify our language on this, and got to a place where they gave us a bunch of suggestions, and we took the majority of them, and felt like we had really productive conversations. And so by all means, we've been working closely with them to make sure that this is a bill that represents all interests. I will also say that where this bill is coming from, and the language and the pieces of it are from conversations with dozens, tens of of students and survivors across Nevada who have really made it clear what they need and what is currently missing. And so I will say yes, we have talked to NCHE folks and those people, and we've talked in great length with students and survivors who have expressed how much is lacking and how much they need. And, we feel really confident and, good about this bill being really, again, those first steps to addressing this epidemic. Happy to answer any further questions on that. Thank you.
Thank you. I think we have Angie on the line. Either I think it's audio, maybe. Is that right? BPS.
Hi, Chair Dennis. This is broadcast. Yes, we do have number 269. Please stand by as I work on getting them to unmute. Caller with the last three digits, 269. Please proceed.
Hi, this is Tina Russum, spelled Russom. I'm a Deputy General Counsel for the Nevada System of Higher Education. I am calling on behalf of the Nevada System of Higher Education. I wanted to clarify NSHE's position on this bill. Our position is that we are neutral in our support of this bill. So we are Nevada System of Higher Education. We've been engaged in conversation with the senator since last Friday. We submitted amendments to Senator Scheibel in her office. However, without a full friendly amendment, we're not comfortable with the language as it is. And we want to make sure that any audit or any amendments comply with federal law. We continue to look forward to working with the senator and her team. However, Nevada's System of Higher Education's position does remain in the neutral position. Thank you for your time. I yield back.
All right, thank you. Any other questions? Yeah, Senator Hardy. I think you're unmuted.
I am now. Thank you. So if NSHE were on the line still, we could ask them what the incidence of sexual violence is in the NSHE programs. And in a follow-up, where did we get the 5% of something that we don't know what the other denominator is? And if we have 5% of people that have complained and have been victims, then we have a pretty good idea where to start, how to prevent. So the concept of do a study and do this and that to find out what to do for prevention, we already know that. And we already have a good focus group that will help us say what we need to do. So I think this bill, with all of its problems, is problematic. I don't think it's a good idea. Thank you.
Thank you. Let's see, switch views here. Any other questions? I will say that I know that there are issues and I know that they are working on them. Obviously trying to get all this stuff done, especially in this particular year, has been difficult for folks. I think there's some merit in what is trying to be accomplished here in the bill. I think I heard Dr. Hardy earlier in Commerce and Labor say it's not soup yet. But I think that there are some things there that we could do and want to have that opportunity to give you to be able to work. I know that somebody mentioned the one over in the assembly. They're working on some things. I think as you guys communicate, I think you're going to find some things that can work, and we can get some of these issues. And it's a complex issue. There's a lot of concerns, right? And we have victims, we have persons that are accused, we have all these different issues, right? And trying to figure out what the best solution is. So I am comfortable in being able to give it an opportunity to continue on, so we could try to work some of those issues out. It probably has a fiscal note on it. I can't remember, but I'm sure it's going to probably get some of that have to be figured out. So I'm comfortable in that respect. Other questions? Senator Donate?
Motion to amend and do pass.
Okay, if we have no other questions, we have a motion from Senator Donate. Do I have a second? Senator Lang, is that you trying to take?
Chair Dennis.
We have a second from Senator Lang. Senator Donate, do you have a it's a comment? So we have a motion and a second comment. Senator Donate.
Thank you so much, Chair Dennis. The only comment that I wanted to mention really quick is that I commend Senator Scheibel for bringing this forward. From the conversations that I had with the ACLU and a few other organizations, I know that there are still some kinks that need to be figured out to ensure due process and justice. And, you know, along the conversation on prevention, I think we can accomplish a lot of this by supporting comprehensive sex education reform. It's simple as that. And I know that based from my undergrad experience, too many times have my friends and classmates been devastated from the treatment of student conduct officials when dealing with their sexual assault case. And we need to do more to advocate for the victims that have watched their universities stand by with inaction. So I know there's a bill coming forward from the Assembly side that helps accomplish this, and that there are things that we still need to find a common ground with, but I am supportive of this bill, and I hope the remainder issues can be solved throughout this process.
Thank you. Further discussion on the motion? Okay, so we will go to the roll call vote.
Vice Chair Dondarlu,
Yes.
Senator Hardy,
No.
Senator Hammond,
No.
Senator Lang,
Yes.
Senator Buck,
No.
Senator Donate,
Yes.
Chair Dennis.
Yes, and I look forward to seeing what can come. So thank you for that. The motion passes. I believe it was 4-3. Let's go to the next item. I think we have Senate Bill 347.
Thank you, Mr. Chair. Jen Starm, Committee Policy Analyst, and I believe, and pardon me if I'm wrong, the next bill on work session is Senate Bill 354.
Oh, yes.
And Senate Bill 354 was presented by Senator Dennis on April 5th. The bill relates to school discipline and restorative justice practices. The measure requires the Department of Education to develop a statewide framework for restorative justice. Restorative justice plans developed by school districts must align with the statewide framework. These plans must also include input from students. The measure modifies procedures relating to suspension or removal from school. Additionally, the bill requires a school to offer certain services to a student who is temporarily removed from school. Senate Bill 354 makes various changes to statutes relating to suspension, expulsion, and removal from school to recognize students who are homeless or unaccompanied, and provides that a student may not be expelled or suspended from school in certain circumstances. The bill requires the Department of Education to include a related indicator in the statewide system of accountability. And finally, the bill provides for the discipline data collected by public schools. We did receive several amendments here, which are also attached to the work session document. The first is from Nevada's Department of Education and My Brother's Keeper to replace the term indicator with data. And then the second set of amendments from My Brother's Keeper includes 1, amend provisions in section 6 concerning services and considerations for students temporarily removed from school. 2, amend provisions in section 7 concerning a removed student's return to include those in foster care. 3, amend section 8 regarding students who are habitually disciplined to include the consideration of a determination made by a local representative. 4, amend sections 10 and 11 regarding the suspension or expulsion of students who are at least 11 years old to include considerations for foster youth and to include certain school representatives or other liaisons in determining behaviors. Next, the proposal would amend section 14 to change the effective date for purposes other than preparatory administrative tasks, including training requirements, from July 1, 2021 to July 1, 2022. And finally, proposed amendment would move the requirement for the Department of Ed to develop a statewide framework for restorative justice from Chapter 392 of Nevada Revised Statutes to Chapter 388. Mr. Chair.
Thank you. Questions? I know we do have some folks on here. I think we still have, Sarah Nick from entry or from the department and some other folks. Senator Buck.
Thank you, Chair Dennis. So my question is, a lot of our underserved communities end up with, more discipline issues, just because kids come with trauma and different things. And so the last thing that I would want to do is publicly, mark them as a bad school because, students are coming and maybe we just need more training for those schools to, implement positive behavior systems and that sort of thing. So I'm going to be a no on this just because I think that it really does mark our most underserved communities in a negative light.
Thank you. Just want to remind you, the reason I brought this bill is that we've got kids that are homeless that are being treated differently because of their situation. We're trying to work on that issue, that they need to be given some special consideration because of this circumstances they can't control. Other questions? Okay, I will entertain a motion.
I'll make a motion to amend and pass.
Have a motion to amend and to pass from Senator Lang. Do I have a second? Senator Donate. Further discussion on the motion. Okay, let's do the roll call vote.
Vice Chair Dondero-Loop,
Yes.
Senator Hardy,
No.
Senator Hammond,
Yes.
Senator Lang,
Yes.
Senator Buck,
No.
Senator Dunyate,
Yes.
Chair Dennis.
Yes, thank you. The motion passes. Okay, before I forget, for the floor statements for 102 Hammond, you do that. 126 Senator Dondero-Loop. I will do 172 Dondero-Loop, 210. Senator Harris, 287, Senator Scheibel, 347, and I will handle 354. All right, that's the only items that we have on our agenda today, except that we need to go to public comment. So if the if we could have BPS put on anyone wishing to give public comment, you're limited to 2 minutes.
Thank you, Chair. If you would like to participate in public comment, please press *9 now to take your place in the queue. Once again, if you'd like to participate in public comment, please press *9 now to take your place in the queue. Chair, the public line is open and working. However, there are no callers at this time.
All right, thank you very much. that's all we have before us today. We got to the deadline day today, and we have no further items to come before us. Want to thank staff. I know it's been difficult trying to get all this stuff and all these amendments, and trying to get so that we can be able to have a discussion and vote on some bills, and appreciate all that great work that staff has put forward. Appreciate members being here today and the discussions that we've had. As we can tell, there's a lot of passion when it comes to education, and we're all trying to do what's best for kids and as we move forward. So I appreciate that. So with that, we don't, I think that's all we have for now. So we're done with the work that we need to do. So we are adjourned. Thank you.
Senator Dennis.
Yes.
Afternoon.
I am not planning to meet Monday at this point.
Okay.
That could change. So just keep an eye on the thing, but I'm not planning to at this point.
Okay. Thank you.
All right. Thank you and have a good weekend.